Hi, I'm Nicole Slowey, the Operations Director here at Qdos Contractor. In today's video, I'm going to be speaking to you about IR35 reform. In this session, what we'll cover off is what the reform is coming into play 6th of April 2021 now, what challenges organisations might face both client and agency side, as well as some more specific questions on some areas that organisations want to get into the detail of, especially in advance of the introduction of the legislation in a few weeks' time, and also for them to incorporate that into their planning and preparation activities that they are undertaking now. Starting with what IR35 reform is. The introduction of off-payroll legislation into the public sector in 2017 is essentially what started where we're at now. So what we're seeing coming into fruition now in 2021, albeit this was originally supposed to be introduced in 2020 but was delayed due to the COVID-19 pandemic, as an extension of those public sector rules. And what the rules actually mean in the public sector and what the rules will mean going forward in the private sector for organisations who are considered medium or large is that those entities will now have the burden, the responsibility and the requirement to comply with the off-payroll legislation when it comes to thinking about the IR35 status of individual workers that they engaged who are providing their services via limited companies. So if we take a supply chain as an example where we have a contractor, a recruitment agency and a client. Under the off-payroll legislation, that medium or large client will have an obligation to undertake a form of status assessment on the contractors that they engage. As part of that responsibility, the client has to take reasonable care in arriving at that determination. The client has to issue a status determination statement to both the worker and the next party to them in the supply chain. So in the supply chain we just talked about, the recruitment agency. And that status determination statement needs to outline what the status is that the client has arrived at, as well as include rationale as to why that determination has in fact been made. So that's the responsibilities that the client has, is specifically making a determination, issuing an SDS and sharing that through the supply chain. The statement I made there around reasonable care is another real point of consideration. So organisations, client side, need to make sure that when they are undertaking those assessments that they're doing so accurately, that they're taking a full view of the facts around the contractor's circumstances into account, and that they're introducing enough robust compliance processes in order to substantiate and make those correct determinations. If a client fails to do that, then that could potentially mean that the client becomes liable in the event of an IR35 inquiry. An additional responsibility that clients are going to have going forward is the requirement to have a client-led disputes or challenge process. That means that organisations have to design and introduce a mechanism whereby if they make a determination, issue the SDS to the contractor, and it so happens that the contractor is considered inside of IR35, then the contractor needs to have a means or a mechanism to raise a challenge against that. And clients have an obligation to have that process in place and communicate and respond to any disputes raised by contractors within 45 days. Now again, if the client fails to meet those obligations under the legislation, they assume the financial liability in respect of the contractors should there be an HMRC investigation. Now, if we play that right the way through, we've covered off the client responsibilities around making a determination, reasonable care and requirements for a challenge process. There's then a split whereby the fee payer in the supply chain then has their own responsibilities and liabilities in respect of the legislation as well. So the fee payer is the entity who physically pays the contractor's invoices. And per the supply chain we talked about, we have client, recruitment agency and contractor. So in this scenario, the recruitment agency and the supply chain is in fact the fee payer. So the fee payer has the responsibility to in effect apply the determination that has been made by that client. So should a client organisation consider a contractor to be inside IR35, then the recruitment agency must make steps to ensure that the relevant taxes are deducted at source, and that's their obligation under the legislation to do that. If they fail in their obligation, they are ultimately liable as well. Likely that often sees that contractors would either be engaged via an umbrella company where they're found to be inside IR35 or agency PAYE type models. Now, there are other models out there in the marketplace where a contractor can receive a deemed payment via their own limited company and keeping that intact. But given the administration that's involved around that, most organisations, fee payer side, tend to stick to offering contractors PAYE options or umbrella company models. Now, it's important to note that not only does the fee payer have the obligation for applying the client's determination, and where that's inside, they need to make the deductions. Where that's outside, then a contractor can continue to use their own limited company. But that's also another area of potential financial risk for those organisations. Now, per the legislation, if the client undertakes reasonable care, fulfills all of their responsibilities as they are required to do so, passes the determinations on to the contractor, in the event of an incorrect determination, where we potentially have, say, 10 contractors considered outside of IR35 and 5 contractors considered inside IR35, the agency makes the deductions for the 5 contractors, and in good faith, on the basis of the determinations made by the client, they continue to pay those 10 contractors outside of IR35. Now, if those 10 outside IR35 determinations were incorrect, it is in fact the fee payer, the recruitment agency in this supply chain, who would actually be financially liable for any taxes due under the legislation per HMRC's investigations activity. What are the issues with reform? Now, we've talked about what the reform actually is, and I think that most people would be able to see quite clearly what the potential issues with the legislation changes actually are. First and foremost, the fact that the legislation splits the responsibility for making determinations and the liability in respect of those incorrect determinations between 2 parties is one of the biggest issues. If you're a recruitment agency or any other type of fee payer, you're ultimately taking on board a financial risk on the basis of a determination that your client has in fact made. So there's a huge amount of risk financially that fee payers are taking on, and that's why a lot needs to be done in fee payers and their clients working together to ensure that the status determination processes and the status determination partners or tools that are used to arrive at determinations, that both parties are actually comfortable with that, because there is that split responsibility and liability. Second to that, and because there is now a financial risk client and recruitment agency side, lots of organisations are taking a risk-averse approach, and the utmost risk-averse approach that these organisations are taking is actually a blanket policy decision to say that they'll no longer engage limited company contractors. That is not the intention of the legislation. The intention of the legislation is to ensure that individuals and entities are paying appropriate amounts of tax that are using these types of engagement models. The intention is not to unnecessarily remove contracting as a limited company contracting specifically as a vehicle for organisations accessing resources and services, and similarly for specialist skill set individuals providing those services back to those organisations. And in addition to that, it's also taking a piece of what is known as quite complex legislation. Now, keeping in mind the only changes are around the administration as far as who is responsible and liable, not the principles upon which the legislation is actually built, and expecting clients to have designed a IR35 compliance process and developed IR35 specialisms within their organisations in order to mitigate that risk appropriately and make sure that they're fulfilling their obligations to the fullest extent that they probably can. Now, given where we're at in the time frame and that we had a postponement in 2020, we actually originally thought at one point the reform legislation was going to be introduced into the private sector in 2019. HMRC would argue that organisations have had enough time now to get themselves upskilled, increase their knowledge, or in fact engage with specialist providers of tax advisory services, specifically on IR35, to make sure that they are prepared ahead of the legislation. With the implementation of the legislation and in advance of the implementation of the legislation, it presents a number of recruitment difficulties and a number of difficulties for recruitment agencies specifically. So we talked a bit about the fact that recruitment agencies will now be financially liable in the event of a determination being considered by HMRC as incorrect, subject to the client having taken reasonable care. So what that means is even if the client has taken reasonable care but still gets the determination wrong in HMRC's eyes, the recruitment agency will still be responsible for the back payment of those taxes, interest and penalties that could become due as part of any IR35 investigation or off-payroll investigation. So that's one of the principal challenges for recruitment agencies, in that there's a real big risk consideration around how they're actually going to continue to engage and utilise and have limited company contractors operate through their supply chain. Secondary to that is the fact that clients in some cases are taking that blanket ban. And with that blanket ban, what that means is that organisations will have in fact put recruitment agencies in such a position whereby umbrella company and agency PAYE are being presented as the only options. And for contractors who are engaging via their limited company at the minute, where there is potentially no increase to rates, and we can come on to talk a little bit more about that in a second, that in effect those contractors are going to be taking a significant take-home pay cut. So the challenge for agencies that then creates is the administration around implementing PAYE contracts and changing them from limited company contracts. Similarly to that of the paperwork and the administration are involved around the contractor being introduced to and in turn engaged via an umbrella company. And then also the point about rates. So a lot of clients who have taken those blanket ban decisions have in fact said that under no circumstances would a contractor be met halfway, would a contractor see any sort of rate increase. So ultimately, those additional employment and employment costs, both employee and employer side, will in fact be met by effectively the contractor's rate. So that can see something in the region of to be around 26 to 30% of our like-for-like rate reduction for contractors. Everyone's circumstances are different, how they pay themselves are different, and their own personal tax strategy can impact that a couple of different ways, but that sort of gives you a feel. So all of these things into the mix then present a potential challenge for recruitment agencies actually finding the right type of resource in skill sets and specialisms that clients in fact need as part of the key projects that they're trying to deliver. So what that could present is a potential flight risk when you're thinking about an existing contingent labour workforce. It could present challenges to then in turn replace them. So on a like-for-like basis, would another contractor take that type of role at that type of rate on an inside IR35 basis? So it's going to become quite apparent as we grow nearer the implementation date of the legislation, as well as post-implementation, what kind of effect that's actually going to have in terms of availability of expertise and specialisms in the marketplace, and then the potential knock-on effect that might have in client organisations around key projects and important projects. So a lot of the considerations and discussions that agencies and clients will have had, most certainly before now, but continuing to have at the minute, will be around how they can perhaps manage and mitigate their way through those potential challenges around inside determinations, blanket determinations, and what inside IR35 looks like, both from a payment perspective, i.e. the model, as well as then financially what that looks like from a rate perspective for the contractor and also for the client as far as the cost implications of potentially increasing rates as well. In the description box below, you will see that there is a link to a free guide. The guide covers off in great detail all the specifics around the reform that we've covered off in today's video. You can also subscribe to our videos to make sure that you stay up to date with future updates from Qdos. As always, if you ever have any questions, please don't hesitate to get in touch with Qdos. Leave a comment in the comments box, and also make sure that you subscribe in order to get access to any future videos that we publish on the subject of IR35 and all other contracting matters.